The next case we're going to talk about is the second child support case. It's marriage of Sare. This case deals with reimbursement claims for overpayment of child support. We start by looking at the party's 1992 judgment, which orders father to pay mother $425 per month in child support and $286 per month in spousal support. After the divorce, mom serves a wage and earnings assignment order against dad's place of employment, resulting in a garnishment of the child support and spousal support orders. The wage and earnings assignment order is not self-terminating. In April 1995, father's spousal support obligation ends, and he doesn't wait. 2 months later, he goes over to the courthouse and he files his modification of the wage and earning assignment order, and the spousal support garnishment is terminated at that point. Now, child support is still being garnished at this point. In January 2001, the child turns 18 and graduates from high school. That's the end of child support per law. However, the wage and assignment order related to child support remains in place all the way until 2008. So they keep taking money out of his paycheck, and we don't know why it ended in 2008. The decision doesn't say. He waited until November of 2021, at which time he files a request for the court to order the mom to pay him back the overpayment of child support, and there's a code that allows that. In his request, he asked the trial court to order mom to reimburse him in the amount of $46,000 plus interest. Father also asked the trial court to order mom to pay his attorney's fees and costs. Mom opposes his request, arguing that he waited 14 years for the alleged last date of the wage being garnished to make it known that he was coming after her. She further argues that she should be prejudiced by this delay and points out that father knew the proper procedure to terminate the wage and earnings assignment order since he took the appropriate action when he got rid of the spousal support garnishment. So he knew what he was doing. There's no excuse for that. So this is a laches defense. You know, and I think we always thought that laches didn't apply to child support anymore. Well, in this instance, apparently it does. In April of 2023, the trial court denies the father's request after finding father did not take timely action to seek reimbursement from the mother, and therefore his request for reimbursement is time barred. In so ruling, the trial court notes that it applied Family Code Section 3653, subsection D, which sets forth factors to consider when determining whether to order a repayment of child support. The trial court remarks, well, here the issue for the court is that the father waited 14 years to finally come to court and say, I've been paying and I overpaid and I want my reimbursement. And it says, look, if you came to me, let's say somewhere around 3 to 5 years afterwards, I probably would have granted your request, but you've waited too long. But the court says, I do believe that mom had unclean hands on this, and I don't believe it is fair that she receives a windfall. However, in the balance of things, I do find that father played a major role in this. So the trial court denies his request, he files an appeal, and the Court of Appeal affirms. In deciding the case, the Court of Appeal first addresses mother's laches defense. The court agrees that the defense of laches does not apply here, since the trial court made a finding that mother had unclean hands. And this is the part that I thought was interesting, because we know that laches doesn't apply unless you're going against the government, right? If the child support services is coming after for unpaid welfare, you could still use that defense, but the defense against private attorneys or private people is long gone. But when we're trying to get reimbursement for overpayment, laches does apply. Okay, but in this case, it doesn't apply because she had unclean hands. Next, the court addresses whether mom was responsible for notifying the father of the fact that child support order had expired. Now, Family Code Section 4007B does say that, if it's ordered, that the party is going to have to, notify you of some kind of a significant event, but that didn't apply here because the judgment didn't say that, so mom had no duty to do so. And in any case, the Court of Appeal noted that the father did not need to be told because he knew, based upon the fact that he knew that the child was 18 years of age, graduated high school, and by law, it was terminated. Since the wage earning assignment order was not self-terminating and the original dissolution judgment didn't require mom to notify him of the happening of the contingency, it was father's responsibility. The Court of Appeal affirms the trial court's order. So one of the things that I think that we should all take away from this is if we're representing a payer of support, there's some things that we could do. One is write a CYA letter right at the end of the case and say, hey, by the way, there's a garnishment here, and Your job is to do something proactive to get rid of that garnishment, because just because by law it's changed doesn't mean that it's going to, you're off the hook there. The second thing is maybe you ask the court, look, if you're going to issue the garnishment, how about making it self-terminating? And I didn't even know such thing exists. I know there are some good friends who are in this business of judgments and stuff probably already knew that, but I didn't know that. And then also, you could ask the court to say, tell her or tell him, about some event that's changed. If it's a spousal support order, hey, let us know when you get married again, okay? Put the responsibility on the other person.